Hi, everyone. We're back. Welcome to this week's episode of Law Chats with John and Amy. I'm John Yulian.
And I'm Amy Poliafco. This week's question is, what is a divorce trial like?
Okay. That's not a simple question. And if you haven't been involved in a divorce trial, I always say it's never as exciting as it looks on TV.
I think that's the
Uh,
simple answer. Nothing like you've
yeah,
ever seen on TV.
and one of the major differences um, that you find out is a divorce trial does not involve a jury. So when you watch all these shows on TV, these legal shows on TV, you see trials and you see a jury there. But divorce trials are always just in front of whatever judge or whoever you happen to have as a judge in your divorce case. And it's the judge who's going to hear the evidence and ultimately make the ruling and the findings in the case. So it's a little bit different than you might anticipate with a jury, but the process is still the same. And Amy, maybe you can talk about what has to happen before even the trial begins as far as exhibits and witnesses.
Yeah, sure. So when the judge issues a trial date, which realistically most of the time is between 6 months and a year out from your last court date, they issue an order that says this is the date when all your discovery has to be done by. This is the date when you guys need to exchange exhibits, which are the actual physical documents that you're presenting as evidence to the judge. And any motions in limine, which you can do another podcast on what a motion in limine is, but essentially um, any request by the judge, just anytime you're requesting the judge to not allow discussion about some certain topic or fact, that needs to be handled ahead of time. And those motions will be done before the trial begins. And so the day that you go into court, you're going to have, not you, your attorney, will have a binder of exhibits that both sides agree should be exhibits that the judge should see. And those will all be numbered, 1 to whatever. And then any exhibits that the other side doesn't agree to, those are called contested exhibits. Those will be in a separate binder. And you'll need to get the judge to accept those if you want them entered in. And then before trial, we'll have exchanged witness lists. So you'll know who your spouse is calling as a witness or who they potentially could call as a witness. And then, John, do you want to talk about what we do to prepare for a trial?
Sure. And I just want to back up to follow up on what you were talking about, Amy. I think a lot of times, and it needs to be really emphasize with the clients how expensive divorce trials are. And Amy was just talking about some of the reasons it's so expensive because we haven't even gotten to the trial portion yet. And Amy just described how you have to put together, in conjunction with the other side, an exhibit book with agreed upon exhibits and then the exhibits that are disputed. And that means the exhibits our side wants admitted. That's not even taking into account the exhibits the other side wants. Then the time spending, negotiating over which ones you're in agreement on, not an agreement on. Having said that, if we jump ahead a little bit, to prepare for the trial, in addition to the exhibit books and the witness list that we have to do, we need to make sure we as attorneys, so in our case, it would be Amy and myself, making sure that we've prepared sort of a guide of the questions we want to ask each of our witnesses, that we want to bring up as questions for any witnesses the other side's going to call. We want to make sure we have our client and any witnesses we're going to be using come into the office so we can do some practice runs of the type of questions we're going to ask, and they can get practice of responding to questions. So once again, we still haven't, you know, actually appeared at the trial yet. This is all preparation work. Amy, do you want to just sort of um, follow up on that as far as any other aspects of, the preparation?
Yeah, so to give an example, the last trial that John and I did together was this big multi-day divorce trial. And so here's a list of every question. John was going to do the direct exam of our clients. And I had a binder to follow along with, okay, well, John's going to ask about the financial statement on this date. So I'm going to have my hand on that financial statement in case John needs to have access to it, or our client needs to know where it is in the exhibit book so that she can review it if she has questions about it, or we're talking about a specific email or a photo. So we need to have those on hand at all times. So it's not only just preparing those original books, but it's also any documents that we might rely on. And then any contested exhibits, when do we want to bring them up? We want to make sure that in the notes that John had, well, if I'm talking about what the house is worth and they don't agree with our valuation, I have a note that's so John knows that this is the time we want to present that exhibit. So it's a lot of detail, it's a lot of paperwork. For every hour of testimony, multiple hours go in ahead of time to prepare for it. And then John, you want to talk about what the day of the trial is like? If the
Sure. So when you actually have the day of the trial, everybody's there at court, and the judge may or may not have you make opening statements. A lot of times, the judge could say they're really not necessary. I'm familiar with the case, so let's just get started with having the witnesses testify so we can move the case along. And one side is going to be the plaintiff who's going to present his or her case first. So that means whoever the plaintiff is, those witnesses are going to go first. Each witness goes up, and if Amy and I were representing the plaintiff, well, we would ask the questions, meaning one of us would ask whatever questions are going to be asked, and then the other side gets to do what's called a cross-examination and ask whatever questions they want of that witness. And then we go through with the witnesses we want to have so that we're presenting our case. And after we get done presenting our case, well, then the other side gets to present their witnesses, their evidence, and their case. And once again, this is very time consuming. One of the unusual aspects that, once again, on TV, you don't see this because a lot of times they're criminal cases, but people are surprised when you can have one day of trial and then the next day is maybe a week later, 2 weeks later, and you have your next day of trial because you have to work within the availability of the judge and what dates are available for a judge just to isolate for your particular case. So people are always surprised when they're like, gee, we don't have another hearing for a month or, another day of trial for an extended period of time, but
I
that's how it goes. Yeah, go ahead,
I was
Amy.
going to say, I think that's not even the biggest surprise when the trial finishes because they expect a decision that day. And that will never happen. Most of the time, the judge will require post-trial pleadings. So that could be submitting proposed orders or proposed finding of facts and law for the judge to review. And then the judge writes up his or her decision, which we've gotten, and I kid you not, I'm going to call this quick, 3 months after the trial. But I know that you've had other cases where it's been like 18 months.
Sure. And I have to tell you, I always think somewhere in the range of 6 months to a year. And sure, if it comes in a shorter period of time, that's great. It once again depends how complex the case is. But as Amy points out, once again, it's not like TV where you're getting a decision right away. So the case is over, and yet you're going to wait, whether it be 3 months, 6 months, a year, to get a decision from the court. And I think what you should be realizing from this presentation is you need to always make your best efforts at a settlement or a resolution. There are some cases where they need to go to trial and everybody's made their best efforts to come to an agreement and it just doesn't happen. But if you're playing hardball and holding the line and not willing to compromise and causing a case to go to trial, I think in the long run you'll regret it because you are just going to pay a tremendous amount more in legal fees. The case is going to take much longer to be completed. So I strongly encourage anybody involved in a divorce, make your best efforts and good faith efforts at a compromise whenever possible.
All right. Anything else to add, or do you think that's good for the day?
I think that's a good point. We want to finish before everybody's heads are spinning. So I think that's a good ending point.
All right. Well, thanks for joining Law Chats with John and Amy. We look forward to chatting with you again next time.
If you have a question or comment, feel free to email us at info@ulianlaw.com. Remember that Law Chats with John and Amy is intended as a general reference and considered general advertising, and listeners should check for changes to any applicable laws and consult with an attorney on any legal issue. The information provided does not constitute legal advice, and any thoughts or commentary by the podcasting lawyers is provided as a service to the community and does not constitute solicitation of legal advice. The lawyers in the law firm of Julian & Associates PC make no warranties and disclaim all liabilities for damages resulting from its use. Nothing provided in the podcast should be considered a substitute for advice from counsel. No attorney-client relationship is formed by listening or participating in this podcast, and in the event that the podcast receives emails about the subject matter, no attorney-client relationship is created via the email communication.